Sit in mo ato.
Shutdown?
Oo.
Mo lang pag nagpunas ka. Ano ka kasi? Saan ka dito?
Ano? Facebook na? Ha? Facebook. Hindi nga tinatawag ko kasi nilipat ko doon kasi ako gumagamit sa laptop eh. Ngayon nilipat ko sa iPad, Facebook Live na. Mali yung ginamit mo, chatroom yun, hindi limited eh. Mali, hindi yun.
Ay, ayaw.
Na, ito nga, tingnan nyo kung nandito na kasi hindi na laptop ginamit ko, iPad. Oh. Ha? Ano yan? Hindi nga, nandiyan na, may nag-message na nga, naka-FB live na. Baka kayo lang ang wala. Mali kanina eh. Doon, mali yun, chatroom, mali yun eh. Hindi yun. O ito, may nag-message na. FB live na. O sige. Ilawin mo lang doon sa yun na, patay mo yun. Yun na lang ang ilaw. Okay, nilipat na. Ito na, live na. Hindi na sa... Kaya ako nagtataka kanina, ba't may makakita akong audience? Yung pala, chat room. 25 lang, kaya nagtataka ako, 25 lang. Alright, so ulitin na lang natin. Ulitin na lang, sayang. Kunti pa lang naman lang nasimulan. Alright, bail as a matter of right or a matter of right or a matter of discretion. So I repeat, if one is charged for the crime of if one is charged for the crime of attempted homicide, bail is a matter of right. Ibalik natin, pasensya na kasi sayang din eh. Bail is a matter of right. Why? Because the penalty is only reclusion temporal. Homicide of 12 years and 1 day to 20 years. So, bail is a matter of right. So, bail is a matter of right. Now, if one is charged for murder, bail is not a matter of right, but a matter of discretion. Why? Because the penalty for murder is what? Reclusion perpetua for 20 years and 1 day to 40 years. In other words, if an accused is being charged for a crime wherein the penalty is only is less than, wherein the penalty is less than life imprisonment or life imprisonment or reclusion perpetua, bail is a matter of right. So the court cannot refuse the application for bail. Reason, because that is a constitutional right. Bail is a matter of right. But if one is charged for life imprisonment, a crime wherein the penalty is life imprisonment or reclusion perpetua, life imprisonment like the selling of shabu, the delivery of shabu, then bail is not a matter of right but a matter of discretion. So yun lang, paano natin malaman na bail is a matter of right? Pag ang penalty is less than reclusion perpetua or life imprisonment, bail is a matter of right. Bail is a matter of right. But if the penalty is reclusion perpetua or life imprisonment, bail is only discretionary. The court may or may not grant the bail. So if one is charged for a crime wherein the penalty is reclusion perpetua or life imprisonment, bail is a matter of discretion, right? So since it is a matter of discretion, it may be granted or it may be denied. The petition for bail may be granted or may be denied by the court where the evidence of guilt is strong. In other words, if you are asked, may a person charged for murder or illegal sale or delivery of shabu or rape, as we mentioned, rape of the first kind. Dalawa yan. Yung first kind, reclusion perpetua. Yung object rape, yung the second kind, billable yan kasi reclusion temporal. Alright, one was charged of rape for the first kind. Is bail a matter of right or a matter of discretion? A matter of discretion. But if you are asked, can a person charged for a crime wherein the penalty is reclusion perpetua or life imprisonment, can he post bail? Kung yan ang tanong, yes, he can post bail. But take note, not a matter of right. Yun ang pagkaiba. But a matter of discretion. Matter of discretion. Bakit naman ganun? Because the penalty is reclusion perpetua or life imprisonment. So, how can a person charged of a crime where the imposable penalty is reclusion perpetua or life imprisonment post bail? How? By filing a petition for bail in court. You have to file a petition. Then, if a petition for bail has already been filed in court, the court will set the case for hearing, a summary hearing for that purpose. For what purpose? To determine whether or not the evidence against the accused, the evidence of guilt is strong. The prosecution then will present evidence for that purpose. In fact, the burden of proof to prove that the evidence of guilt is strong is on the part of the prosecution. Take note, the burden of proof to prove that the evidence of guilt is strong lies with the prosecution. I'm not saying the burden of proof to prove that the accused is guilty. Hindi guilty ang pinag-usapan. Whether or not the evidence of guilt is strong. Kasi bakit? Petition for bail lang ito. This is not a hearing on the merits, no? But simply a petition for bail. Bakit nga petition for bail? Because bail is a matter of discretion. Pero kung ang bail is a matter of right, paano ka makapagpiyansa? Madali lang. By simply an application for bail. Saan? Tutag sa court. Clerk of court. Or sa court. Sa branch ng court. You apply for bail. Application lang. Anong bail ang gagamitin mo? It may be a cash bond. Cash. Halimbawa, 200,000. Mayaman ka. Automatic, 200,000. Mahirap ako. You can go to the surety. It's 200,000. Pababayarin ka siguro lang ng 20% of 200,000. Kung hirap din yan sa pag mahirap ka, saan ka kukuha ng 40,000? Aber? Hirap hanapin yan 40,000. Sa mga mayaman, baliwala. Sa mahirap, napakahirap. Wala nga mabili ng pambiling bigas eh. And that is why sa jail facilities, either it is provincial or city jail, whatever, punong-puno, lalo na itong mga city jail. Bakit? Kasi nga hindi makapagpiyansa. Ang liliit na kaso. Hindi naman nakapagpiyansa yung tao, kaya nabubulok sila doon. Tapos kaya lang, babanat na yung iba dahil sa kahirapan sa buhay. Kasi talagang nasa kahirapan. Sino ang maraming nakakulong sa jails? Mahihirap ang karamihan. Nagreklamo naman yung kumukontra sa gobyerno. Kasi nga, dito sa bansa daw, walang hustisya pag mahihirap. Gagatungan pa ng ibang lawyer. Senador pa magsasalita na lawyer. Kasi hindi sila makakuha ng magaling na abogado. Kalukuhan yun. Hindi yun totoo. Walang pangpiyansa. Yun ang dahilan. Yung nabubulok sa kulungan. So, bail is a matter of right or a matter of discretion. Alright. Meron namang tinatawag na motion to fix bail. Oh, ano itong motion to fix bail? Suppose your client, the accused, is charged for a crime wherein the imposable penalty is reclusion temporal to perpetua. Kadalasan, pag ganyan ang kaso, anong nakalagay sa information? No bail recommended. No bail recommended. Sinusunod lang naman ng prosecutor. Hindi naman kasalanan nila eh. Even the ombudsman. Sinunod lang yung bail bond guide. So, no bail recommended. But question, is a crime punishable by reclusion temporal? Is a crime punishable by reclusion temporal to perpetua bailable? Is bail a matter of right? In so many cases, the Supreme Court said yes. In crimes punishable by reclusion temporal to perpetua, bail is a matter of right. So a bail should be recommended in the information. But suppose there is no recommended bail in the information. You are the counsel for the accused. What would be your remedy? Okay, what would be your remedy? You simply what? File a motion to fix bail. Tandaan nyo to ha. Yung kanina, if bail is not a matter of right, petition for bail, right? Pero if bail is a matter of right, you apply. Application lang ng bill ito. Punta ka, mag-apply ka lang. Surrender ka lang. But if one is charged for what we mentioned, punishable by reclusion temporal to perpetua, ang nakalagay doon, no bail recommended. Your remedy is to file motion. To file a motion to fix bail. Okay. Yung tanong naman iba. In filing a motion to fix bail, is it necessary that the accused should surrender himself? Take note, last time we discussed that a person who is free is not entitled to post bail. According to the Supreme Court, it is incongruous to post bail, to allow a person to post bail who is free. Sinong magpo-post ng bail? Nakakulong lang. Bakit mo papiyansahan yan? But here your remedy is to file a motion to fix bail. I repeat, nakalagay doon sa information, no bail recommended. But the penalty is reclusion temporal to perpetua. So your remedy is to file a motion to fix bail. O, ang tanong, is it necessary that your client, the accused, should surrender himself to the court? Because according to the Supreme Court, it is incongruous to allow a person to post bail when he is free? No, there is no need. Why not? Because he's entitled to bail. But no bail was recommended by the prosecutor. And that is why you are filing a motion to fix bail so that the court will fix bail. Yung mga recommended bail na nakikita nyo sa information, prosecutor ang nagre-recommend nun, hindi judge. So, motion to fix bail. Pag granted na, oh wow, granted. Alright, granted. Your motion is granted. Motion to fix bail is granted. Okay, granted na. Sabi ni judge, okay, granted 500,000. Alright, remember that your client, the accused, is still at large. How can now he post bail? This time, after the granting of the motion to fix bail, after the court fix the bail, this time, your client should what? Your client should surrender na. The court should have acquired jurisdiction over this person so that he can post bail. Yun yung motion to fix bail. Okay, now, we mentioned a while ago that in a petition for bail, the burden of proof that the evidence of guilt is strong lies with the prosecution. Alright, so here is now a petition for bail. Petition for bail. The prosecution presented its witnesses to prove that the evidence of guilt is strong. Alright, after the summary hearing, the court finds the evidence for the prosecution not strong. So your client is now entitled to post bail, right? Now you are the trial judge. What would be the appropriate grounds for you to allow the accused to post bail? Remember, no bail is recommended. You have to look into financial ability of the accused. Kung sabihin mo namang 500,000, pala ang pamilya niyan basurero isang kukuha ng 500,000, wala. So the court should take into account the financial ability of the accused. Ibaba mo. Another one is the court should take into account the nature and circumstances of the offense and what is the penalty for the offense charged. Another one is the character and reputation of the accused and about his age. 85 na siya. Sabi niya, 85 na pala. O sige, tama na yung 30,000. Okay na, labas na siya. Or, is suffering from an illness. Those matters shall be taken into account by the court in fixing the bill after petition for bail is granted. Another matters to be taken into account is that tatakas ba yung accused na yan? If I will grant bail na ganito lang, naku, most probably tatakas, itaasan mo. The court can increase the bail because of the probability that the accused will not appear during the trial. Take note that why is it that accused should post bail? That is to guarantee his appearance in court, where his appearance is required, like for instance during arraignment. Another one is the fact that the accused was a fugitive from justice when arrested. Ang dami pala niyang kaso. Ang dami, tambak ang kaso niya on bail siya pero tumakas. Hindi itaasan mo ang piyansa. And of course, other pending cases. Of course, according to the Constitution, excessive bail shall not be allowed. Right? Excessive bail shall not be allowed. According to the Constitution, excessive bail shall not be allowed. So, the amount of bail shall be reasonable. At all times. It should be reasonable at all times. Kasi according to the Constitution, excessive bail shall not be required. Okay. Now, all right. Of course, the petition for bail, we already mentioned that, is a mere summary hearing. Now, in a petition for bail, the prosecution shall present only pieces of evidence that are essential in determining whether or not the evidence of guilt is strong. That is the only purpose, to determine that the evidence of guilt is strong. Yun lang ang purpose, not to prove that he is guilty. Okay, ito na. During the summary hearing for a petition for bail. Okay, petition for bail. Summary hearing. The prosecution presented 3 witnesses. to prove that the evidence for the prosecution is strong so that the petition for bail will be denied. Yan ang nasa utak ng prosecution, ma-deny yan. Sa accused naman, mag-grant. Okay. Question. After the prosecution presented its witnesses, about 2 or 3 witnesses, question. You're the counsel for the accused. Are you bound to present evidence to contradict or rebut the prosecution's evidence? There is no need. The accused need not present evidence to contradict or rebut the prosecution's evidence. Sa rules of court, this is not clearly so provided. But under the revised guidelines on continuous trial for criminal cases, it is expressly provided that the need not present evidence to contradict or rebut the prosecution's evidence. Bahala na si judge. You decide. Judge, decide. Alright, now, okay, summary hearing. After the summary hearing, okay, presented na only 2 witnesses. The court did not yet decide whether or not to grant. Wala pang decision. Ang question is that, pending resolution by the court of the petition for bail, pending, may the prosecution present evidence on its trial on the merits, meaning to prove the guilt of the accused beyond reasonable doubt. Diba? O, so, diba? Halimbawa, ngayon, nag-present the last witness for the prosecution for the purpose of petition for bail. Kinabukasan, before the resolution of the petition for bail was issued by the court, the prosecution presented evidence on the merits, pangdagdag na testigo, not for the petition for bail, but on the merits. Question: is the prosecution allowed to present evidence while awaiting the resolution of the petition for bail? Answer is yes, under the revised guidelines on continuous trial. The court shall not suspend the presentation of evidence in chief while awaiting for the resolution of the petition for bail. The trial on the merits shall proceed, notwithstanding the pendency of the resolution of the petition for bail. Anong reason ng Supreme Court? Di ba gusto nyo mabilis? Speedy trial, that's it. Speedy trial. Huwag mong antayin. Mamaya kasi baka mag-object. Halimbawa sa exam, bar exam, the prosecution presented evidence is 4th witness after the petition for bail, but before a resolution was issued by the court. The accused objected. We object, Your Honor, to the presentation of the 3rd or 4th witness. Oh, why? Because this court has not yet resolved our petition for bail. Alright, you are the judge. Ask the examiner. Rule on the motion. That was the question asked in the bar examination. Yan ang tanong. Resolve. Anong sagot mo? Ay, ang sagot mo dyan, huwag mong sabihin na the motion is without merit. Pero hindi naman mali yan. Hindi naman mali without merit. Or the contention. Ito yung hindi maganda. The contention is not tenable. My goodness. You are the judge. You are not asked whether the contention is tenable. Anong sasabihin mo? Motion granted or motion denied? Motion, ang pinakatamang sagot, motion denied. Yun lang ang sagot mo. Motion denied. Huwag mong pahabain ng motion. Sabihin, the contention is not tenable. Therefore, motion is denied. Mali ba? Hindi naman. Pero hindi impressive yun na sagot. Pinahirapan mo yung examiner mag-check ng papel. So your answer, just like in a court proceeding, all right, denied. Motion denied. Doon ka na, after the motion to denied, doon ka na babanat ng reason. Why denied? Well, under the rules of, Under the revised guidelines on continuous trial for criminal cases, the court shall not suspend the presentation of the evidence in chief while awaiting the resolution of the petition for bail or even awaiting for the result of a motion for reconsideration. Okay, huwag niyo kalimutan yan. Baka tanong sa bar exam, magandang pang tanong sa bar, codal provision lang. Alright. Now, your client is charged for the crime of slight physical injuries. Pumunta sa opisina mo, nangonsulta. Attorney, ito, nakademanda ng crime ng slight physical injuries. Slight physical injuries or slight physical injuries or unjust vexation or any other light offenses. That is what I am driving out. Alright. Should your client post bail? Should your client post bail? Anong sasabihin mo? Huwag ka na magpiyansa. Huwag ka na. Ikaw na, attorney, ito, nakasuhan ako. No need. Why? Because those crimes, slight physical injuries, they are governed by the rules on summary procedure. An accused charged of a crime which is governed by the rules on summary procedure need not post bail. Actually, nakalagay yan sa sa information. Bail not required. Bail is not required. Minsan nalilito yung iba, ano yan? No bail pala. No. Bail is not required. Pero pag nagkamali, no bail recommended. Iba yan. Petition for bail, mali. Nagkamali yung prosecutor dyan. So, no need. So, if an accused is charged for an offense governed by the rules on summary procedure, no need of posting bail. Okay, marami yan. Mga reckless imprudence resulting to slight physical injuries. Bail is not required. But suppose your client was charged for any crime governed by the rules on summary procedure. So, ano nakalagay? No bail required. No need to post bail. So, your client was notified. Notified of what? The arraignment. Ngayon, sabay na, tandaan nyo, under the revised guidelines on continuous trial, arraignment, sabay na yan, pre-trial. Arraignment. But your client did not appear during the arraignment despite notice. Nako, lagot. Because the court will issue a warrant for his arrest. Under that circumstance, even if your client is being charged for a crime governed by the rules on summary procedure, this time he has to post bail. Kaso sino ang magsasabi ng mag-recommend ng bail? Si judge ang magsasabi. Siya hawak na yan. Hindi na prosecutor ang magsasabi. Kung sabihin ni judge 10,000, wala kang magawa, 10,000. Pero minsan itong mga judges, kaya later on some of you will become prosecutors, dapat alerto kayo. Kasi yung judge, palaasa din yan sa piskal. O piskal, magkano? Ganun sasabihin. Siyempre, kung ikaw piskal, taasan mo. Usually 3,000 ngayon, yung bago. Dati 2,000, ngayon 3,000 na ang bail dyan. Nagtanong si judge, anong sabihin mo? 10,000. Sobra naman piskal. Tinanong mo ako, 10,000. Bahala na si judge. Gagawin niyang, hindi, piskal, 5,000 na lang. Okay? 5,000. Okay, so, alright, now, the application for bail. Pag sinabing application for bail, bail is a matter of right. Right? Take note. Pag application for bail, bail is a matter of right. Tanong, where will you post bail? Where will you apply for bail? Okay. Saan? Siyempre, you should file the application for bail in the court, with the court where the case is pending. So, if the case is pending before the RTC Branch 1 or MTC Branch 1, then post bail before RTC Branch 1 or MTC Branch 1 as the case may be. Right? So, with the court where the case is pending. Ano yan? Application. Take note, application for bail. Nako, nag-apply ka ng bail. Wala yung judge. The trial court is absent. Is available. Which one? The judge of the court where the case is pending. Problema mo ngayon, laking tanong, question mark. Well, where will you now file an application for bail? Saan ka pupunta? Maraming judge, di ba? Marami. Then, it should be filed with the regional trial court or municipal trial court judge in the locality. Doon ka mag-post ng bail. Bakit? Because the judge is not around. Or if there is an executive judge in multiple sala courts like in Metro Manila, Antipolo included, Cebu, Cagayan de Oro, Davao, yung mga malaking syudad, meron yan, multiple sala courts yan. Meron namang executive judge. Doon ka, wala sa executive judge. Ini judge. Remember that bail is a matter of right. The accused should not be deprived of his right to post bail simply because wala si judge. Meron namang ibang judge. Alright, now how about where the grant of bail is a matter of discretion? Why? Because your client, I repeat, is being charged for a crime wherein the penalty is punishable by reclusion perpetua or life imprisonment. So, bail is a matter of right. Saan ka? Bail is not a matter of right, but a matter of discretion. Your client is being charged for an offense. Anong penalty? Reclusion perpetua or life imprisonment. So, bail is a matter of right. Saan ka magpa-file? Where will you file the petition? Where? Of course, where in the court where the criminal action is pending or on trial, or if it is already on appeal before the appellate court. Suppose it was granted. All right, granted. Where will you now post or apply the bill? In the court where the case is pending. Ano to? Where bail is a matter of discretion. Okay, now, all right. Now, suppose that the accused was wanted to be released on recognizance. Yan ang nabanggit natin kanina. Recognizance. Walang perang involved dito. Walang property. Walang surety bond. No need. But somebody else should answer for you that you will appear in court when necessary. Lumabas ang bagong batas. Okay, so where will you file an application for release on recognizance? It should be filed only in the court where the case is pending or on trial or on appeal. So, if the case is before Regional Trial Court number 1, well, an application for release on recognizance shall be filed before the Regional Trial Court number 1. Okay, it should be number 1. We will discuss release on recognizance later on. Okay. Now, how about a person? Although nabanggit na natin ito when we were discussing Rule 112 on preliminary investigation. Well, according to the rules, Rule 114, any person in custody, codal provision lang ito, any person in custody who is not yet charged. Okay, tandaan nyo, a person in custody, kakulong na, who is not yet charged, can he post bail? Can he post bail? The rules of course is, yes, he can post bail, he can apply for bail, provided that the offense for which he is being charged is bailable. Bail is a matter of right. So where? Well, he can apply in any court in the province or city or municipality where he is being held. Right? Paano nangyari ito? A person not yet charged and yet detained. Paano nangyari? Well, we discussed that when we discussed on the rule on inquest. A person was arrested without warrant. Correct? So, according to the rules of court, he shall be brought immediately to the nearest jail or station. That is what the rules of court said. And according to the revised penal code, he shall be brought to the judicial authorities within 12, 18, or 36 hours. Otherwise, the detaining officer could be held criminally liable for delaying the bringing of the detained individual to the judicial authorities, punishable under Article 124, 125 on arbitrary detention. Okay, maliwanag. Okay, now, he will be brought to the office of the prosecutor for inquest before being charged in court. Now, after the inquest and before being charged, can he post bail? Ayun ang sinasabi. Yes. Anong sabi natin noon? You can simply ask for a what? A certification. Certification from whom? Certification coming from the inquest prosecutor that your client is detained and being charged for this particular crime with a corresponding bail recommended. That certification will now be utilized for posting bail in court. Ang masaklap, maraming mga judges dyan, hindi nila alam din. Marami, bakit? Hindi kasi nakalagay, although maliwanag sa rules of court, the procedure is not specified in the rules of court. Kaya malabo. But there is, of course, a Supreme Court ruling on that. And that Supreme Court ruling was adopted by the Department of Justice in the rules of procedure. Okay. Now, your client was already admitted to bail. He is now free, right? Alright. How about the court? May the court increase or reduce the amount? Yes. Yes. Usually, increase yan. Hindi nire-reduce. Bakit? Nag-jump bail? Nako. Tinataasan yung nag-judge yan. Meron pang mga judge na stricto, pero I agree with them. Alright? Cancel the ban. Double the ban. Nako. May mga, yan ang tama. Astig. Tama nagpo-post ka ng ban, di ka sumisipot. Double the ban. Okay. So, if the accused fails to appear in court during arraignment, his bail bond will be cancelled and will be declared forfeited. Nako, kung cash bond yan, 200,000, hindi ka dumating. No, your bond will be cancelled and forfeited. Sino nang may-ari? Di napunta sa gobyerno. Wala kang magawa hindi ka sumipot gobyerno. Alright, now, this one we already discussed, but we have to repeat this one. Bondsman. Siyempre, surety yung bond mo through surety. Bakit? Kulang yung pera mo, kaya surety, bayad ka ng premium. Nako, medyo yung bondsman medyo wala na masyadong tiwala sa'yo. Walang tiwala. Okay. May your bail bond be cancelled? Yes. The bondsman will notify the court, of course, and of course the prosecutor that the bail will be cancelled. But the bondsman can do that only after surrendering the accused. Or if the accused is already dead, his bond shall be cancelled na. Alright, so we also mentioned last time on warrantless arrest that for the purpose of warrantless arrest, the bondsman may arrest the accused or may even ask police officers or any other officers to cause the arrest of whom? Of the accused. Without warrant ito. Yun ang napag-usapan natin noon. Without warrant. So, an accused released on bail may be arrested without warrant. What else? Nag-discuss na natin noon nakaraan. Sarap ng buhay mo Nandun ka na sa airport, international airport. Pero minamatyagan ka na pala ng mga CIDG or NBI or any other police. Nandun yung complainant. Nako, eksakto. Punta ka na ng immigration, pusas na agad. Can you be arrested without bail? The answer is yes. Without warrant of arrest? The answer is yes. Because the accused attempts to depart from the Philippines without the permission of the court. Alright, now, it is a common jurisprudence that once the accused posted bail, pag nag-post ka na ng bail, it means that you are submitting your person to the court. In other words, the court already acquired jurisdiction over your person by the fact that you posted bail. Right? But Suppose that as a lawyer, your view is that the warrantless arrest is not valid. Can you still question the validity? Can you still challenge the validity of the warrantless arrest despite the fact of posting bail, despite the fact that your client posted bail, meaning he submitted himself to the jurisdiction of the court? Yes. The fact that the accused already posted bail, it will not bar him from challenging the validity of the warrantless arrest. Paano yung sinasabi na nag-submit na siya sa jurisdiction of the court? Regardless, remember that the right to post bail is a constitutional right. How about if there was a warrant of arrest? Your client was arrested by virtue of a warrant of arrest. Kulong. Your client posted bail. Now, after posting bail, can your client still lawfully challenge the legality of the warrant of arrest? The answer is yes, he can. The fact that he already posted bail does not necessarily follow that he cannot challenge anymore the legality of the issuance of the warrant of arrest. Your client can still move for the quashal of the warrant of arrest, right? Still, he can. Again, I repeat, because the right to post bail is a constitutional right. Another one. Your client was arrested without with a warrant of arrest, but there was no preliminary investigation conducted, or your client was not afforded the opportunity to answer the charges against him through a preliminary investigation. So he posted bail. Can he still question the fact that there was no preliminary investigation, even if he already posted bail? Yes. But take note that in all cases we discussed, the motion or petition questioning the validity of the arrest should be raised before entering a plea of guilty or not guilty during the arraignment. Because once the accused allowed himself to be arraigned, he already waived such right. Dapat bago mag-arraign, gagawa ng paraan na wag. Do not allow your client to be arraigned. Otherwise, he cannot question anymore the validity of the warrantless arrest. Otherwise, he cannot question anymore the legality of the warrant of arrest. Otherwise, he cannot question anymore the fact that there was absence of a preliminary investigation. If your client was not afforded his right to a preliminary investigation right at the moment of the arraignment or before the arraignment, your counsel, the counsel shall make manifestation, have to inform the court that your client was not afforded his right to a preliminary investigation, and you have to make assertion that my client would like to avail of his right to a preliminary investigation. If you are the judge, what will you do? You have to refer back the case to whom? To the office of the prosecutor for the preliminary investigation. But if you allowed your client to be arraigned, no more. Your remedy is go to trial. Proceed with the trial. You cannot question anymore the legality of the warrant, of the validity or legality of the warrant of arrest or the warrantless arrest. Okay, so dapat before arraignment. Okay, as we mentioned a while ago, posting of cash bond or surety bond or property bond or bail is not the only means of granting release of an accused. He can be released from custody under the release on recognizance. Recognizance is a mode of securing release of any person in custody or detention for the commission of an offense who is unable to post bail due to poverty. Hirap siya, wala. So, recognizance. Kaya hindi totoo yung mga sinasabi nila na mayroong injustice kasi mahihirap. Hindi, recognizance nga. Hindi kailangan ng pera. Hindi kailangan. Okay. Is released on recognizance a matter of right? Yes. Release on recognizance is a matter of right in offenses, not punishable by reclusion perpetua or life imprisonment. So if your client is being charged for the crime of homicide, can he be released? And he is now detained. Can he be released from custody? Can he be released from custody through recognizance? The answer is yes. Nung araw, hindi po pwede yan. But because of the new law, po pwede na. Republic Act 10389. Because of the new law, your client can now be released on recognizance. No money involved. The only qualification of your client is poverty. Walang kapera-pera ito. Wala. Yun lang. Alright. Okay, so when can a person be released on recognizance as a matter of right? Yung mga crime na ang penalty is less than reclusion perpetua or life imprisonment. Before conviction by the MTC. So your client was charged for attempted homicide. So jurisdiction is with the MTC. He is now detained. Can he be released from custody through recognizance? The answer is yes. So before being convicted, he can post bail. He can be released on recognizance. Now, he was convicted. Your client was already convicted. He was on provisional liberty on recognizance. Can he be allowed freedom? Yes, still a matter of right. In the same manner that if your client has posted cash bond, he is being charged for the crime of attempted homicide. He was convicted by the MTC. Bail is still a matter of right, pending appeal. Labas ka pa. Kaya minsan nagagalit yung iba. Bakit nakalabas yan? Di ba convicted na? Anong crime? Attempted homicide. Ay, kahit convicted na yan, kung nag-appealan naman yan, there is an appeal before the regional trial court, bail is still a matter of right. Okay, now, your client is charged for a crime punishable by reclusion, by prison mayor or reclusion temporal. So, jurisdiction is with the regional trial court. Jurisdiction is with the regional trial court. Question, is your client entitled to post bail? Yes. Can your client be released on recognizance? Yes. A matter of right. It is a matter of right. But once your client is guilty, found guilty for the crime of homicide by the regional trial court, he cannot be released on bail. He cannot be released on recognizance as a matter of right. But still, he can be released on recognizance. He can still be released on bail as a matter of discretion na lang. The court may not allow you to be at liberty. The prosecution may even oppose your application for bail because once convicted before the regional trial court of the crime of homicide, alright, or frustrated homicide, bail is not a matter of right anymore. Released on recognizance is not a matter of right anymore, but simply a matter of discretion on the part of the court. Alright. So, recognizance. So, where will you file the application for release, motion for release on recognizance? It should be in the court where the case is pending. Kaya lang paano? Mahirap ito. Kaya binabatikos ko ito, yung batas na to. Bakit? Ano ang mga requirements dito? Nako, one of the requirements for release on recognizance is that there must be a motion for that purpose before whom? The court where the criminal action is pending. And, anong gagawin ng judge? Nako, the court has to notify the city or municipal sanggunian where the accused resides. Politika. Yun ang galing ng mga politiko, congressman. Ba't sinasali dito ang sanggunian? Bakit? May palakasan dito. Bakit? Paano yan kung walang konsihal na mag-sponsor sa'yo? Kalaban ka nila sa politika, hindi yan nila palulusutin yan. O kalaban ka ni Mayor, hindi yan i-approve ni Mayor ang resolution. Because, why? The court shall then notify the city or municipal sanggunian. And, ikaw, halimbawa, ikaw yung vice mayor, city or municipality. Aba, automatic yan. The sanggunian, kasi ikaw yung vice mayor, ikaw ang busing dyan sanggunian. The sanggunian shall include in its agenda the notice from the court upon receipt of the request o notice of the court. So magkakaroon ng session ngayon. Aba, isasama yon sa agenda yung release on recognizance. Di mayroong tatayong konsihal na pabor sa'yo. Pero kung maliliit na munisipyo, kilala ka nila, kalaban ka nila sa politika, tsak yan, kukontrahin ka nila. O kaya kausapin ka, mga kamag-anak, sige, papayagan namin release on recognizance, magpasa kami ng resolution to be approved by the sanggunian, the vice mayor, and later on by the mayor. Basta sa sunod, iboto nyo na kami. Yan ang masama sa bansang ito. Ibang po, itong mga congressman yung pinasasali pa yung sanggunian, release on recognizance lang, sinasali pa. Para political drama talaga ng bansang ito. Well, anyway, that is the law. We have to follow the law. All right. Now, there are instances that your client, the accused, is disqualified from the benefits of the release, the law on release on recognizance. Remember that the accused should execute a sworn affidavit on his application to be released on recognizance. So, merong affidavit yan. Merong affidavit. Naku, nagsinungaling. There are untruthful statement in his sworn statement, in his affidavit. That would be a ground for the denial on release on recognizance. Another one, nag-apply ka o release on recognizance. Naku, ang dami na palang kaso dyan. Nalaman ni Piskal, naku, dami yan. Sabi ng mga police, Piskal, ito yan, present ang mga kaso, ang dami. Naku, he's a recidivist, quasi-recidivist, or habitual delinquent, or he committed a crime aggravated by the circumstances of reiteration. The prosecutor will oppose your application, your motion for release on recognizance. Another one is that if the accused has been found previously to have escaped from legal confinement or evaded the sentence of the conditions of his bail or release on recognizance before, your motion for release on recognizance will be denied by the trial court. Kung ikaw naman ang trial court, pag nakita mo yan, it should be denied. If you are the prosecutor, file an opposition for the release of the accused on recognizance. You have to oppose, right? Alright, ano na itong susunod? I-release na. Naku, ito na naman. Somebody will guarantee that appearance of the accused during the trial. Ang tawag nito, custodian. Luma na yan nung araw, ganun na rin noon. Merong custodian. Usually, mga konsihal, kagawad, they will execute an affidavit. An affidavit of undertaking to the effect that the custodian will undertake that should the presence of the accused will be required by the court, he will bring the accused to the court. Ikaw, papayag ka? Ikaw ang custodian? Naku, wag na. Mahirap yun. Gusto mong tumulong? Piyansahan mo na lang. Piyansahan mo na lang. Kaysa yung recognizance pa. Alright, so what are the qualifications so that one will be classified, will qualify to become a custodian of the detention prisoner? Aba, that person should have a good repute and probity. And what else? That custodian shall be a resident of the barangay where the accused, where the applicant resides. Kabarangay mo. Maganda naman para sigurado mo, mai-present mo. And of course, another requirement is that the custodian must not be a relative o hindi ka kamag-anak, must not be a relative of the applicant. May limitation naman within the 4th degree of consanguinity or affinity. So, second cousin, first cousin, hindi po pwede. Okay. Now, who else? What are the qualifications of the custodian? Marami, dapat the following sectors, membro ka ng simbahan na yan, or maging teacher ka, membro ng academe, or social welfare, or the health sector, o ito mga cause-oriented groups, or charitable organizations. Then, the members of those institutions will qualify to become a custodian. Okay, anong duty ng custodian? Ay, kaya mahirap. Huwag kayong mag-custodian. You have to undertake yung binanggit natin to guarantee the appearance of the court of the accused whenever required by the court. Ang hirap nun kasi babantayan mo siya, baka tumakas na. So, mahirap. Now, there are instances that a release on recognizance was already granted by the court. And yet, subsequently, the court will issue an order for the arrest of the accused on recognizance. Now, how? If there is a manifestation, usually by the prosecution or the private offended party, which is meritorious, showing that the accused should not be released on recognizance, then he will be arrested. And another one, nakatanggap ka na nga ng notice na you have to appear on this date. You did not appear. The court will issue a warrant for his arrest because of the failure of the accused to appear on trial. Another one is, meron kang ibang kaso accused, nirelease ka na nga. Meron ka na namang ibang kaso involving moral turpitude. The court will cancel the release on recognizance and you will be arrested. Another one is that nakalabas na yung accused on recognizance. Bakit? May nag-sponsor na konsyal. The accused is now harassing whom? Harassing the complainant. He is now harassing the witnesses or the prosecutor or the lawyers or the witnesses in the court. If you are the judge, if there is a manifestation to that effect, then you can issue an order for the release for the accused, for the warrant of arrest, for the arrest of the accused released on recognizance. Alright, now suppose that the accused was found guilty. Nasa loob siya ng kulungan. Found guilty. Well, he started serving his sentence. Or the decision is now final and executory. Question, can he still be released on recognizance? I repeat, the judgment convicting the accused has become final, or the accused has started serving the sentence. Question, can he be released on recognizance? No more. The benefits of release on recognizance shall not be allowed in favor of the accused after the judgment has become final or when the accused has started serving his sentence. Okay, so we are now through with Rule 114. At least naalis yung Rule 114. Yung mga nabanggit natin, those are the most important point on bail. Yun ang pinaka-importante. Pero mayroon pang importante na hindi natin take up. Kaya you have to read it. You have to study very, very well. Lalo na those who will be taking the bar examination. Sabihin mo, ba't mo sabi yung lalo na, paano pala itong mga second year taking criminal procedure or fourth year taking remedial review to? Pareho lang yan. Binibigyan ko lang ng emphasis itong kukuha ng bar. Pero pareho lang yan. Alright. We now move on to Rule 115 on the rights of the accused. Actually, the rights of the accused enumerated under Rule 115 are actually also in general enumerated under our Constitution, right? So, example, in all criminal prosecution, the accused should be entitled to the following rights: to be presumed innocent until the contrary is proved beyond reasonable doubt. That is a constitutional provision, right? Presumed innocent. We will discuss that one by one. Presumed innocent. Ano yan? A person charged in court, he is innocent. Bakit? Constitutional provision, he is presumed innocent. As a matter of fact, the accused need not present evidence to prove his innocence. No, it has the prosecution who has the burden of proof to prove the guilt of the accused. This time, not strong evidence anymore, but proof beyond reasonable doubt. But of course, in so many jurisprudence, including the caudal provision itself, when we say proof beyond reasonable doubt, does not mean absolute certainty. No, what is required is only moral certainty, and that would suffice to hold the accused criminally liable. Okay, another right of the accused is to be informed of the nature and cause of the accusation against him. Saan nakalagay yon? The accused shall be informed of the nature and cause of the accusation against him. Saan mo makikita yan? Sa information. In the allegations of the information, nakalagay yon, the nature and cause of the accusation against him. Kaya lang may tanong, when is the formal time? When is the formal time that the accused is notified or is informed of the nature and cause of the accusation against him? Well, that is during arraignment. Yun talaga. Pero actually, alam na ng accused yan kung he availed of his right of prosecution. He is already aware of what is the act or omission being charged. But according to the Supreme Court, the first formal fact of the information of the nature and cause of the charges against the accused is during arraignment. Okay, another one is that constitutional provision, rules of court, the accused has the right to be present in court. And of course, to defend in person and by counsel at every stage of the proceeding, from arraignment, pre-trial, and promulgation of judgment. But I repeat, arraignment, pre-trial, sabay na yan. Arraignment ngayon, automatic yan, diretso pre-trial under the revised guidelines on continuous trial. Okay, so arraignment, to be present. And that is why, if you recall yung mga fourth year ngayon o yung mga nagre-review sa bar, if you recall your rules on evidence, specifically the child witness rule. Under the child witness rule, there can be a hearing wherein all individuals shall be required to leave the courtroom. Sinong matitira? Natural yung judge, court personnel, the prosecutor, and the counsel. Pero si accused hindi pwedeng alisin dyan. Because the accused has the right to be present in defending person. Hindi pwede siyang paalisin dyan. Of course, there are measures. We will study that in the rules on evidence later on. Alright, sa ngayon, hindi natin muna i-discuss. Malilito tayo, maubos yung oras. Alright, may the accused, I repeat that the accused has a right to be present during the trial up to promulgation of judgment. But can he waive his presence? Yes. He already posted bail. He was already arraigned. The accused may or may not appear in court. That would be the waiver of the accused of his right to be present during the trial. Waiver yan. Ayaw ko na mag-appear dyan kasi galit ako dyan sa mga mukha ng mga complainant sa mga testigo. Hayaan ko lang sila. Saka na lang ako mag-appear sa court when the time comes that I will be presenting my evidence. But if the court issued an order for the appearance of the accused, specifically for the purpose of identification, and the accused failed to appear. Sorry for you, Mr. Accused. Once you are duly notified, the accused, the court will issue a warrant for your arrest. Ay, kaya pumunta ka. Kahit na i-waiver naman, ay hindi, inutusan ka to appear. You have to appear in court. Alright, now, we mentioned about the right of the accused to counsel. Now, may accused be allowed to defend himself? Ayaw ko ng abogado wala akong tiwala dyan sa mga abogadong yan. No? Nako, may bayad yan. Pumasok ka lang sa opisina, may consultation fee na. Mayroong acceptance fee. Yung mga tao, ang daming, iwan ko, mga lawyer na may bayad. Bakit may bayad? May hirap kasi sa attorney na yan. No? Acceptance fee agad pagpasok ng opisina. Pero, hindi nila tinitingnan. Natural may bayad. Bakit? May opisina yung lawyer eh. May renta yan sa law office. Nagbabayad ng kuryente. May sekretarya. May staff siyang iba. Lahat binabayaran yan. May mga equipments yan. Hindi pwedeng libre lang. Although marami namang libreng lawyer. Sa akin, baha ang consultation libre. Tawag, libre. Itong araw na to, ang dami. Libre yan. Walang bayad yan. Ay, ang sagot ko sa mga iba, magbayad kayo pag sinabi ng lawyer ito ang bayad. Bakit? Ang lawyer pa ba pag sumakay ng tricycle, libre ba? May bayad, di ba? Ang lawyer ba pag bumili ng 1 kilong bigas, may bayad ba? May bayad. Pag bumili ang lawyer ng kalahating kilo ng isda, may bayad ba? May bayad. Kaya, wag masyadong i-down yung lawyer dahil may bayad. Nako, lawyer pa nga ang mga niloloko ng mga kliyente na yan eh. Marami ding kliyente walang puso. Precisely, merong acceptance fee na eh. Actually, experience yan ng mga lawyer nung araw. Noon kasi, wala namang acceptance fee. Attorney's fees ang tawag nila. Minsan, saka na lang, pag nanalo, may down payment. Ngayon, yung mga kliyente, pag nanalo na, hindi yan sumisipot. Wala, hindi nagbabayad. Kaya ang mga lawyer, nakapag-isip, it should be acceptance fee. Tama naman. Tama. Ako, hindi pa naman ako minsan nakatanggap niyan, acceptance fee. Never pa. Alright, so the accused, kasi walang tiwala sa lawyer, can he defend himself? Yes. Upon motion, makiusap ka. Upon motion, the accused may be allowed by the court to defend himself in person. But if you are the judge, i-grant mo agad, tingnan mo. You will grant the motion of the accused that he will be allowed to defend himself when it sufficiently appears that he can properly protect his rights without the assistance of counsel. In fact, there is a Supreme Court ruling saying that no matter how educated a person is, if he do not know the rules of procedure, if he do not know the procedure to prove that he is innocent, then he might be found guilty. This to prove innocent. Bakit? Kasi if the prosecution already presented prima facie evidence against the accused, nakpo, you have to present evidence. You have to refute the prosecution's evidence. Otherwise, you will be convicted. So you have to prove this time to refute the evidence for the prosecution. If you do not know procedural rules, you might be convicted. Okay? Okay, now, another right of the accused is the right to testify as a witness in his own behalf. He cannot be denied that constitutional right to testify as a witness is on his own behalf. But Mr. Accused, Madam Accused, since you are now testifying in court, you will be subjected to cross-examination by the prosecution, either the public prosecutor or the private prosecutor. But how about if the accused did not present evidence? He did not testify. Reason, sabi niya, why should I testify? According to the Constitution, I am presumed innocent, so I will not testify. But are you going to file a demurrer to evidence? No, Your Honor. Basta I will not testify. Patay ka dyan. Well, the fact that the accused did not refuse to testify for himself, his silence will not in any way be interpreted to his prejudice. Hindi, ikaw yung judge, porket hindi nagtestigo siya, sabihin mo na, guilty ito kasi hindi nagtitestify. No, do not entertain that idea because under the Constitution, he is presumed to be innocent. If you want, Your Honor, if you want to convict him, look at the evidence for the prosecution. If the prosecution is not sufficient, acquit him. If he's guilty, then render a decision finding him guilty. Well, another right of the accused, also a constitutional right, is the right of the accused to be exempted. The right to be exempt from being compelled to be a witness against himself. The right of the witness to be exempt from being compelled to be a witness against himself. Meaning, there must be compulsion. Kinukumpil ka. The accused can voluntarily testify, but he cannot be compelled. He cannot be compelled because that is a constitutional right. Huwag mong pilitin kasi presumed innocent. In a case, lumang kaso ito, that was in 1971, 1970, 72, Supreme Court ruling. Hindi nyo alam ito, pero nandiyan naman sa mga libro natin. This is about the Maggie de la Riva case for rape in Quezon City. Sabi ni judge, fiscal, sinong fiscal pa ang tawag nun, hindi pa prosecutor. Fiscal, who is your witness? Aba, yung fiscal, astig. Yes, Your Honor. Our first witness, Your Honor, is the accused himself. Naku, patay ka. Ang fiscal nito was my former professor in criminal law at Far Eastern University, Attorney Bricia. Astig din si judge. Over the objection of the counsel for the accused, the judge says, no, you should testify. Tigas din si judge. So, that issue was elevated, was raised before the Supreme Court. The Supreme Court said, the accused cannot be compelled to testify against himself as what the prosecution did. And, of course, granted or approved by the court. No, he is exempt from being compelled to be a witness against himself. Right? He cannot. Nagkamali si fiscal, pati si judge, kasabwat. Sabi ng Supreme Court, mali. Do not compel him to testify against himself, but he can testify voluntarily. Pwedeng voluntary. Gusto kong magtestigo. Saan? Laban sa akin. Laban sa'yo. Pwede. Nasa sa'yo yan. Alright. Another right of the accused, which is also guaranteed by the Constitution, is the right of the accused to confront the witness or witnesses against him. And how can it be done? Through cross-examination. That is the right to confront, cross-examination the witnesses against him. Sino mag-cross-examine? Siyempre yung lawyer mo. Ayaw ko ng lawyer, walang tiwala ako sa lawyer. Ikaw mag-cross-examine. At tingnan natin kung magkakaya mo mag-cross-exam. Mahirap mag-cross-exam. Hindi ganun kadali yan. Pero beautiful. Ang ganda ang actually the most beautiful part in court trial is cross-examination. But the most difficult one actually is not cross-examination. It is the direct examination. Ang akala lang ninyo ng iba, mas mahirap ang cross. Sa akin, it should be direct examination in criminal cases. Ba't ko nasabi? In my 20 years experience as a prosecutor, doon ko na sabi, ang hirap talaga ng direct examination. Bakit? Kasi mga witnesses namin, sa isang daang complainants, mabuti kung mayroong 2 o 4 na makipag-usap sa amin before the trial. Hindi yan nakikipag-usap. Diyan na yan sa korte, biglang susulpot. Kaya tanong kami ng tanong. That is why mahirap yung direct examination kasi hindi nila nasasagot ng maayos. Yung tanungin mo, ito ang tanong mo, iba sagot. Ay, sus. Kaya natatalo ang prosecution because of that. Babantayan lang niya ng defense. Ito, mga mali. Cross-examination. So, cross-examination. Another right of the accused, which is also guaranteed by the Constitution, is for the issuance of the court of processes. So, the right to have compulsory process issued by the court to secure the attendance of witnesses and the production of other evidence in his behalf. Halimbawa, sinong testigo mo? Yan. The accused can ask the court for the issuance of what? A subpoena ad testificandum or a subpoena dosis tecum. That is his right under the rules of court. Of course, his right under the Constitution. Ay pagbibigyan mo, judge. Pero minsan, sa preliminary investigation, maraming mga tao, including lawyers, huwag niyong gawin ha, nakakahiya yan. Lawyers, complainant or respondent, sasabihin nila kay Piskal, meron pa kaming XO. Tapos, pwede ba subpinahan mo yung testigo? My goodness. Lawyer, magsasalita ng ganon. Sus Maria Santissima. Tapos magagalit yan. Pag hindi nag-issue ang prosecutor ng subpina, piskal na yan, bubo yan. Nalagyan siguro yan. Tanga yan. No. Wala. Hindi. Wala kang sinusubpina lang ang mga parties, respondents in particular, to submit his counter affidavit, but not his witnesses. The prosecutor cannot compel anybody to appear before them during the preliminary investigation. Unlike sa court, that is a constitutional right that can be invoked by the accused for the issuance of compulsory process like what? Subpoena dosis tecum or subpoena ad testificandum. Subpoena dosis tecum, yung presentation of what? The documents or papers, right? And to testify. Pero yung subpoena ad testificandum, to testify orally in court. Mag-testify ka. Pag hindi ka dumating, baka makontempt ka. Buti ko contempt, may kasaling warrant yan. May warrant na muna, kukulong ka muna, you will stay in jail until such time that you completed your testimony in court. Aside from the fact that you will be cited for contempt. Nako. Contempt. May maawa na si judge, nakakulong ka na, multa na lang, 2,000, multa. Isipin mo. Another right of the accused is the right to have a speedy. And of course, walang kinakampihan, impartial. And of course, open to the public trial. Speedy trial. Ito maraming nagkakamali minsan, speedy trial. Yung mga tao sabihin, Piskal, speedy trial na lang. Speedy trial, yung mabilisan na lang. Yung accused naman, speedy trial na lang. Ba't ang tagal na, 3 taon, 5 taon, speedy trial. There is a law on speedy trial. Trial shall be completed within 6 months, within 180 days. Hindi naman kaya ng court dahil sa daming kaso. Hindi naman kasalanan ng court yan. Speedy trial. Paano nagkakaroon ng speedy trial? Right? A constitutional right. Comes now the prosecution. The prosecution during the first debate, arraignment, pre-trial, trial. Alright, trial. Despite a subpoena, the prosecution's witnesses, despite receipt of a subpoena, the prosecution's witnesses did not appear. Dismissed na ba should the case be dismissed outright? Because violation of speedy trial, hindi yun eh. Because the state is also entitled to due process of law. Ang correct manifestation of the defense counsel is that tawag na, sasabihin mo, ready or honor, the defense is ready. Okay, ready. But counsel, wala kang witness ng prosecution, but just the same, Your Honor, we're ready. Ganun lang, tama na yun. Tama na. Ready ka. Second time around. Wala na naman. Wala na naman, despite notice, walang witnesses. May mga judge na dinidismiss na agad, pero mali naman yun eh. The state has the right to due process of law. Ang tama, ganun na naman. Mr. Prosecutor, Madam Prosecutor, Your Honor, please, we do not have, the witnesses are not around despite due notice. May mo, Your Honor, for a receipting. Anong sasabihin ng defense counsel? Well, last time, we do not object, but we shall make a manifestation, Your Honor, that we are ready. And the last time, the prosecution witnesses was also absent, despite the fact that we are ready. We have no objection in the meantime, Your Honor. Alright, no objection, receipt. The third time, ito na, talagang magka-dismissa na yan. Sana naman? Wala na naman, Mr. Prosecutor, wala. Kamot ulo si Piskal. Wala. Ako naman, pag prosecutor, ganyan, nako, bagsik ako nung araw. Totoo to. Wala akong patawad ng ganyan. When I was assigned at RTC Branch 71, Antipolo, maganda yung judge doon, si Judge Caballis, astig. Pag sinabi kong arrest talaga yan. Later on, I was assigned sa Family Court, Branch 72, babae ang judge. Nak, lambot ng puso, buwisit ako doon. Hindi nag-arrest to eh. Ayoko na makipag-away lang sa kanya eh. Kasi nakiusap. Piskal, tulungan mo naman ako, disposal. Walang yan na yung disposal na yan. Buwisit. Eh, mas gusto ko si Judge Caballes. Warrant. Alright, third time, wala pa rin. O, anong sasabihin mo? You're the defense counsel. Anong sasabihin mo? Your Honor, please, this is the third time that the prosecution's witnesses did not appear, despite notice. This time, Your Honor, may we move that this case be dismissed. We are invoking this time the right of the accused, his constitutional right to speedy trial. Naku, patay. Prosecutor, kamot ulo. Minsan yung judge sasabihin agad, Piskal, paano to? Okay, are you amenable? Are you agreeable to a provisional dismissal? When I was a PAO lawyer, anong ginagawa ko? Yes, Your Honor, amenable. Pero nasa utak ko na yan. I am invoking the constitutional right to speedy trial. Bakit? Dismiss, right? The criminal action was dismissed at the instance of the accused. Once it is revived by the prosecutor, anong gagawin ko? Although hindi ako naka-experience na pina-revive, pero pinaghandaan ko yan. Once the prosecutor will file a motion to revive the criminal action, I will oppose it. Why? Because while it is correct that we agreed that the dismissal is provisional, yet, Your Honor, please, we are invoking the right of the accused to speedy trial. And according to the Supreme Court, if a criminal action is dismissed at the instance of the accused or at the motions of the accused invoking his right to speedy trial, that dismissal is not a simple dismissal. It amounts to an acquittal, and thus it cannot be revived anymore. Otherwise, it would violate the constitutional right of the accused to, double jeopardy. When I was a PAO lawyer in Pasig, hindi ko naman nasubukan na nagpa-revive yung piskal. Pero pinaghandaan ko yan. Subukan magpa-revive ka, yari ka. Hindi naman. Pero nung ako'y prosecutor na, ay alam ko na rin yan, wala akong magawa. Right? That is the rule, that is the jurisprudence. Ano magawa natin? A constitutional right. Another right of the accused is the right to an impartial judge or court. Dapat walang kinakampihan si judge. Pag sa tingin mo impartial, you can file a motion for inhibition. But it is seldom done by lawyers. Pero may gumagawa. Pero ako personally, I will not do that unless sobra na yung ginawa talaga ni judge. Actually, merong nangungonsulta sa akin dyan na litigant dito sa Antipolo. Siyempre, allowed naman ako. Allowed na mag-practice. More than 1 year na akong nag-retire. Pero may lawyer ito. May lawyer. Kaya lang, every time may problema, lagi niyang tinatawag. Pero magaling yung lawyer niya. Sabi ko, ang galing ng lawyer mo. Kailangan pa akong tawagan. Hindi, iba. Maganda yung narinig ko rin yung mga sinasabi mo. Alright. Minsan nakapag-isip na ipa-inhibit itong judge. Sabi ko, naku, huwag mong gawin. Huwag na. Hindi naman. So, huwag basta-basta magpa-inhibit. Another one is the right of the accused to a public trial. Pag public trial, ibig sabihin, open to the public yan. Anybody who would like to attend the trial, welcome. Welcome. Pero that is the rule, right? That is the jurisprudence of the Supreme Court. But in actual practice, no. Bakit? Ikaliliit ng hearing room naman, paano ma-accommodate yan? Hindi talaga. Sinasara na lang yung pinto. Punong-puno yan. Ang mga Hall of Justices sa bansa, yung mga, sa ngayon, itong mga standard hall of justice. Ang liliit ng court hearing room. Ang opisina ng mga empleyado ng korte, kawawa, nagdikit-dikit ang mga misa. Si judge, pag pumunta ka sa chamber niya, naku, pag nakita mo yan sa Antipolo, nakapasok ako sa chamber ng judge, yung kaklose kong judge, isip ko ayoko mag-judge. Ang liit ng kwarto niya, punong-puno ng papel, ba't ka pa mag-judge? Hirapan mo sarili mo. Di na. Pag makakita ka ng Hall of Justice na magaganda, kasi paggawa ng local government. Like, alam ko, Marikina, gawa, pero hindi pa ako nakapasok sa, nakapasok na ako pala sa Marikina MTC. Maganda pero hindi naman kalakihan, pero at least maganda. Ikumpara naman sa yung regular Hall of Justices. Sa Makati, maganda raw. Manila, go to Manila, gusto mo punta ka. Pinakakawawa sa lahat ang mga opisina ng judges, prosecutors. Lawyer, iwan ko kung saan na ang PAW ng Manila. Dati sa Boy Scout yan, ang Manila, nalipat. Hindi ko na alam kung saan na sila nag-opisina. Grabe. Walang binabastos nila yung larangan ng patakbo ng justice system sa bansa. Dapat bigyan nyo ng pondong Supreme Court, DOJ, the DPWH for the construction of Hall of Justices na reasonable. Sa Antipolo, kung nakarating na kayo sa Hall of Justice ng Antipolo, yung hagdan doon, dalawang hagdan sa gilid, yung gitna medyo malapad, yung sa gilid ang giliit. Alam ba, one way yan? Hindi ka pwede makipagsalubong ng tao. Talagang tatagilid ka. My goodness. Mas pupunta ka sa ibang ahensya ng gobyerno, ang gaganda ng mga opisina, wala namang mga trabaho, daldal lang, wala namang mga tao. Mali itong gobyerno. Dapat itong mga congressman, wala nang sweldo yan. Laking budget nila, billions. Sasayang. Mas maganda pang martial law, wala namang kongreso. Tumatakbo naman yung gobyerno. Alright, so, now, with respect to presumption of innocence, merong doctrine ng Supreme Court na nagsasabi, accusation is not the same. Accusation is not synonymous with guilt. Hindi porkit nakademanda na guilty. Because, I repeat, sinabi natin kanina, it is incumbent upon the prosecution to prove his guilt, to demonstrate that he is guilty. Okay? Alright. When we speak of the right to counsel, nabanggit natin kanina, actually, it proceeds from the principle that an accused is entitled to due process of law before one can be condemned. So, there must be due process of law. So, he is entitled to be represented by a counsel. So, you have to pass the bar para you can appear in court. Masarap tumayo sa korte. Siyempre, sa simula, mahirap. Siyempre, wala kang experience kahit anong talino mo, kahit anong number 1 ka pa sa bar. Pagdating doon, wala. Mga ngapa ka eh. Pero pag naka-experience ka na, maganda sa court. Alright, the accused has the right not to testify. Because if he will be compelled, as we mentioned, if he will be compelled to testify, that would be violative of his constitutional right against what? Self-incrimination. That is why he cannot be compelled to testify. Okay. Now, how do we distinguish? The right of the accused against self-incrimination and the right of a mere witness against self-incrimination. Well, when we speak of the right of the accused against self-incrimination, once he is called to testify against himself, tinawag pa lang siya, that would already be violative of his right against self-incrimination. He can what? He can object. No, I will not testify. That would be violative of my right against self-incrimination. That is the accused. Once the accused is called to testify, called to the witness stand, automatic yan na ayokong umupo dyan, ayokong mag-testify. Because right from that moment, his right against self-incrimination is already violated unless he will give his consent. Pero ano ba ang tamang procedure dyan? In court. Halimbawa, you're the counsel, mag-object ka na agad. Your Honor, please, we object. That would be violative against his right on self-incrimination. Hindi na yan ang pinakatama. Bakit? It might be waived by the accused. Dapat ang proper manifestation is, well, Your Honor, please, may I make some manifestation? Oh, yes, okay, proceed. May I request, may I pray, Your Honor, that the accused be apprised of his constitutional right against self-incrimination. Alright, granted. Isasabihan mo na ito, hindi ka pwedeng tawagin dyan. Pwedeng tawagin. Kasi violative of your right. Okay. Papayuhan din siya na judge. Sabihin, okay. Pero kung magpipilit talaga siya, he is waiving his right. He is waiving his right against self-incrimination so he can testify. Nag-waive siya eh. Right? But how about an ordinary witness? Well, an ordinary witness cannot refuse to testify. Once he's called to testify, he cannot refuse. So, if an ordinary witness receive a subpoena, he cannot lawfully refuse. And that is why I mentioned that he can be arrested. He can be cited for contempt, right? He cannot refuse. He has to take the witness's stand. But the moment a question is asked of him, a question is propounded of him, which would be violative of his constitutional right, that would be the time that he can exercise that right. But, how can it be exercised? Ay, ganun din ang sasabihin ng counsel. Diba? Nagtanong si prosecutor or the defense. Naku, violative of one's right. Tatanong, Your Honor, please, may I make some manifestation, Your Honor? Yes. Or may I request, Your Honor, that the witness, hindi accused, be informed of his constitutional right against self-incrimination. Informed na, Madam, Sir, kung sakaling sasagutin mo yung tanong na yan, maaring gagamitin niya laban sa you, will be charged criminally. Anong sasabihin? O ngayon, kung gusto mo pupumilit, sige, you will testify ka, pero maaring ikakulong mo yan. O anong sabihin ng witness? Hindi na lang ako mag-testify. See? Meaning, I will not answer that question. So, proceed to counsel, proceed with another question. Ayaw niya eh. Right? So, that is how the right against self-incrimination of a witness be exercised in court. Hindi yung automatic nag-o-object agad. Hindi. Pero yung lawyer, pag hindi alam yung eksaktong proseso, mag-o-object agad yan. Minsan, pagbibigyan na naman ni court ng judge yan. Objection, Your Honor, pagbibigyan na kasi, automatic na. Pero that is not the correct procedure. Pero kung marunong ka, ikaw yung opposing counsel, anong sasabihin mo? You have to oppose. No, Your Honor. That is not the appropriate way, Your Honor. Why? Because he can waive his right against self-incrimination. He should be informed of such right, Your Honor. Yan. Medyo mabulaga. Pag yan ang gagawin mo sa kalaban mo in court, mabulaga yan. Magulat yan. Galing naman. Galing. Pero actually, hindi magaling. Bakit? Saan galing? Supreme Court cases din ito. Hindi naman gawa-gawa dyan. Gawa-gawa. That is the appropriate procedure. Maaring nakalimutan na lang ng opposing counsel. Okay, so patapos na pala. Speedy trial. Speedy trial. Okay, this one. Kanina, speedy trial, right? We now move on to the right to speedy disposition of cases. Iba naman ito. Yung speedy trial, that right can be exercised in court while on trial. But the right to speedy disposition of cases can be exercised even before trial. In fact, it can be exercised during the preliminary investigation. We discussed this one on the right to preliminary investigation. The first one is the case of Tata, then later on Secretary of Perez, and later on, na-mention ko yung isang Commodore of the Philippine Navy. Bakit? Ay inabot kay Tatad almost 3 years. Preliminary investigation pa lang ito sa Ombudsman. Si Secretary Perez almost more than 3 years. Yung isa naman, yung Commodore, if you can recall, inabot ng 14 years ang preliminary investigation. Kasi pabalik-balik sa Commission on Audit. Itong kuwa naman, may mga taga-kuwar pa naman dito. Yung taga-kuha, They conducted an examination of the accounts of the Commodore in Cavite City. Then they filed a complaint before the Ombudsman. Okay, filed. There was a preliminary investigation. Natulog, nakalimutan na lang. Then later on, pasok na naman yung kuha after 10 years. Nako, ito na yung kuha. Conduct naman ng audit against the account of the Commodore. Complaint was filed before the Ombudsman. Preliminary investigation was conducted. Ang preliminary investigation, the subpoena was addressed to in Cavite, the official residence of the Commodore. But he is already retired from the government service. Paano niya matatanggap yan? Bahay lang yan ng mga active service in the military. An information was filed in court before the Sandigan Bayan. If you're the counsel, what would be your remedy? Well, in this case, the accused in those 3 cases, and of course other cases, they moved for the dismissal of the criminal action on the ground that it violated their constitutional right to speedy disposition of cases. Bakit? Tumagal yan kay Ombudsman. Grabe naman, tinugtulugan ng Ombudsman yan. Anong sabi ng Supreme Court? Granted. All those cases were dismissed by the Supreme Court, saying that the long delay in the conduct of a preliminary investigation violated the right of the accused to speedy disposition of cases. In that case, sa Commodore nga, nagpabor pa nga ang Sandigan Bayan sa kanila eh. Yung justification ng Ombudsman, nag-side yung Sandigan Bayan. Sabi na, hindi, kasi ganito yan. Ang daming trabaho ng Ombudsman. Anak ko, sabi sa Supreme Court, no! The fact that there are voluminous work in the office of the Ombudsman is not a justifiable ground to violate one's constitutional right to speedy disposition of cases. The right to speedy trial, the right to speedy disposition of cases is guaranteed by our Constitution. Okay, so sa ligang batas yan, it should not be violated. Okay, so natapos natin, galing, natapos ang rights of the accused. So the next time we will proceed with arraignment. Alanganin na, kung alanganin na, natapusin. Sa susunod, ayos natin. Nagkamali kanina ginamit ko yung laptop. I-chat room pala yung napasok, kaya nagtataka ako, ba't ko nakikita itong ibang mga participants? 25 of them. Kaya nilipat ko dito sa iPad na lang. Hirap din ako, pero okay lang. Yung pala, dito pala sa itong room na to. Itong lecture lang talaga. Although yun nga, hindi ko kayo makikita. Yun lang. May mga messages nga kayo, nababasa ko lang. Pero mas maganda yung mas maganda talaga yung tawag nito sa Zoom. Pero okay lang, nababasa ko naman yung mga message niyo. Maraming salamat din. Tiyaga lang, tiyaga. Yung mga ngayon lang naka-attend sa lecture na to, ulitin ko, this is a free lecture for all law students and bar candidates, for free. This is for free. And kami nga ni sina Duming noon, nag-uusap kami talagang intended lang for criminal procedure. Pati si Jonas, abay, nung dumami na, sabi ko, sige, lahat na lang, the entire remedial law para makatulong. Pumasok pa si Dredd, siya itong may pakana nito na mapaganda. Kasi nung araw, namumblema na kami how others will avail. Kasi yung Google Meet, 100 lang talaga. Laking problema. So ako nga, nag-apply na nga sana ako ng Zoom, yung for 500 participants. Yung pala, hindi naman ako qualified. Hindi pala yung individual dyan, ang makukuha ko lang 100. Dapat pala, yung tawag nito, corporate daw, para 500. Hindi ko na lang tinuloy. Gusto ko sana yun, kasi mas maganda. Mabuti si Dredd, ito, naayos. So, ulitin ko kasi marami ditong mga kababayan ko, may taga Surigao dito, Agusan, marami, Metro Manila. This group was started by law graduates and law students from the province of Isabella. Silang nagsimula dyan. Sina Duming, may mga kasamahan si dyan. Then, mabuti si Jonas, na-meet ko naman in person. Ayan, pumasok pa si Dred from San Sebastian College of Law. Ito na, napaganda natin ito tuloy. Okay, na para makinabang ang marami. Okay, mahirap ang bar exam sa remedial law, pero anong solution sa mahirap na bar exam na yan? Ano? Simple lang. Prepare hard. How to overcome fear? Madali lang. Be prepared for the bar examination. Ako mahina ako sa remedial law. Totoo to. Habang may oras pa, para ma-inspire kayo. Grade ko ng criminal procedure, naalala ko, parang 77 yun eh. Hindi ko maintindihan eh. Judge, isang si RTC judge, hindi ko maintindihan si judge, ano pinagsasabi, puro lang sigaw-sigaw eh. Hindi ko maintindihan. Then, special proceedings, pumasa ako. Hindi ko rin alam ba't ako pumasa. At isipin nyo special proceedings, hindi ko alam ba't ako pumasa. Ang gusto ko lang na subject evidence. Okay yan. Medyo gusto ko yan. Then civil procedure, naku, isa pa, napaka-dry na subject. Hindi ko maintindihan din. Pinipilit na lang talaga eh. Tumaas lang yung grades ko nung remedial law review na. Medyo nag-iba na yung pakiramdam ko. Medyo talagang tinutukan ko na ng maigi. Tumaas yung grade ko sa remedial law review under Justice Oscar Herrera. Kung nakita niyo yung may libro si Justice Herrera, siya yung professor ko nung tumaas. Kaya lang sa preparation for the bar examination, kasi mahina nga ako sa remedial law, every other month, yun ang schedule ko. Halimbawa, October, remedial law yan. May partner na madali. Ganun yan. Then sa November, halimbawa, commercial law, may partner na madali. Ganun lagi yung mahirap, Tapos, pagdating ng December, balik na naman ako sa remedial law. Ganun ko that is how I prepared hard for remedial law. Balik na naman ako ng remedial law. Papartneran ko na naman ng ibang subject. So I was too confident, no not too, I was confident that I will make it in the bar examination for remedial law. Through the book of, thank you, Justice Florence D. Regalado. Maliit pa lang, manipis pa lang yung 2 volumes niya eh. Yung tinagtad ko talaga ng kakamemorya. And that is why, ang nagpapasa sa akin, remedial law. Hindi ko naman sasabihin sa inyo yung grade ko, kakahiya, pero just a few points na, talagang mag-100 na sa remedial law. Bakit? Dahil magaling ako? Hindi yun. Simple preparation. May preparation lang talaga. Do it, and you will make it. You will pass the bar examination. Lalo na itong kukuha na ng bar. Yung mga law students, nako, simula kayo ng maigi, you study very, very hard. Okay, so, thank you. And next Saturday, I repeat, talagang yun yung schedule natin. 6 to 8 na kasi meron akong klase na remedial law review 1 sa PUP. Yung may mga taga PUP dito. Alam niyo, mahal ko yung PUP, dasintang paaralan. Ba't ko mahal ang PUP? I am from Far Eastern University, but I love mas mahal kong PUP. Bakit? Mahigit 10 years na ako dyan. Saka yan ang school nagbigay sa akin ng opportunity to teach in the College of Law. Lalo na yung remedial law with Dean Fistin gave me the opportunity to teach remedial law at PUP. Kaya nga nakapagsulat ako ng libro because of Dean Fistin. PUP. Sa FEO, hindi naman ako pinansin. Although marami kami, hindi naman kasalanan ng FEO eh. We were not invited. Pero actually, I was invited, and in fairness naman, kawawa naman ng FEO. I was invited by Dean Santa Maria nung FEO Law Alumni Homecoming. Although he's not from FEO, he's from Ateneo. Dati kami kasing nag-meet na sa family court. Nagbigyan nga ako niya ng libro ng Persons and Family Relation and Obligations on Contract. Nilapitan ko, nagpakilala ko. Aba sabi, hindi Mario, kilala kita. Tapos, nung magtanong siya kung saan ako, PUP, nung tuturo, anong subject? Civil procedure. Inoferan talaga niya ako ng subject, civil procedure. Sabi ko din, hindi kaya eh. Kasi at the time, I was still a prosecutor, daming trabaho, saka ang layo ng FEU na sa Makati na, hindi na po pwede. So, FEU na lang, PUP, sintang paaralan namin, maraming taga-PUP dito. Of course, the Manila Law College, and recently, I was invited by yung pangmayaman, University of Asia and the Pacific. Okay. Ito, nagsimula sa province of Isabella, of course, Cagayan. And this is not only for the students and graduates of Isabella and Cagayan, but the entire country. Okay, next time. Maraming salamat. Hindi na kasi kayo makapagsalita dito, kaya daldal na lang ako. Okay, next Saturday, 6 to 8. Maraming salamat. Nabasa ko naman yung mga ano ninyo, lecture mga messages ninyo. Pagbutihan natin ito para maraming papasa sa bar exam. Okay, salamat. Maraming salamat. Okay. Okay, sa mga taga Tugigaraw, Cagayan, Raquel, thank you. Meron kang kaklase, Raquel, kasama dito. Kasama. Kilala ka niya. Okay, maraming salamat. Raquel, thank you sa lahat. Thank you. Okay, next Saturday.